And they are rules that apply when the meaning that is there is insufficient to decide an issue, but that the issue must still somehow be decided. Now, with this background in mind, let me now turn to Mike and John's argument for original methods originalism in their Northwestern piece. There is much in their most recent defense of this approach with which I find myself in agreement. I believe it was a major step forward in the development of their theory, and I wrote my earlier comment on original methods originalism prior to them writing their response to my comment. If you read the piece, you'll see they're responding to my earlier comment. So I did not have the benefit of their latest refinement of their position. So let me just emphasize our points of agreement first, because they are not insignificant. First, we agree that the meaning of constitutional language should be ascertained by interpretive methods in existence at the time the language was enacted. That is an important area of agreement. Second, we agree that most cases of ambiguity can and should be resolved this way, by using methods of interpretation. Although I would add, as I did before, the caveat that there may be very special and rare cases of ambiguity, irresolvable ambiguity, that cannot be decided that way. But here's where I think we now disagree. We disagree about the problem of vagueness. We disagree about the problem of what to do with vague language. In their paper, they treat, Mike and John treat ambiguity and vagueness together as a couplet, and as essentially the same problem. Whereas I believe these are two distinguishable linguistic problems. With vagueness, meaning truly does run out. After all, genuinely interpretive methods are exhausted. Now, I do think, and I want to hasten to add here, that when originalist methodology is properly applied, supposedly vague provisions in the text are often much less vague than they are made out to be by people who want to find more vagueness than is there. And for example, my colleague Nick Rosenkranz's scholarship is a brilliant textualist, not even an originalist actually, but a textualist analysis of how much more information is in the text than is commonly believed. And I, for example, argue that the rights retained by the people means liberty right, natural rights, which mean liberty rights based on the historical understanding of that phrase. It doesn't mean any right. So even though it may be still somewhat vague as to what a liberty right is and how you protect a liberty right, it doesn't mean any right you may happen to like or think about. That's the original meaning of the text and context. Vague, but not as vague as advertised. But, and here's where I think we may still disagree, residual vagueness remains and is only concealed by the invocation of rules of construction like defer to the legislature in case of vagueness, which are not the same thing, in my view, as rules of interpretation. So, one final comment on methods used at the founding, which is a subject that was dealt with in Mike and John's paper, but not so much in his comments today. Mike and John say there is no evidence of construction at the founding, that where the founders are using the term construction, and they seem to admit that they use the term construction a lot, they have lots of examples in which the term construction is used, the founders really meant what we are, all of us, referring to as rules of interpretation, or, in the sense that they are trying to ascertain the actual meaning of the text and not doing something extra. They're not supplementing. Now, my own view is that sometimes these rules of construction, what the founders referred to as rules of construction, were indeed rules of interpretation and not what this distinction would label them as rules of construction. And it is unsurprising to me, at least, that the founders who use this phrase sometimes fail to see the difference between which of their rules of construction are really interpretation rules and which of their rules of construction really are in construction, rules of construction. As it shouldn't be surprising that they may fail to make this distinction. Moderns fail to make that distinction all the time. That's one of the reasons why I've gotten so much mileage out of this distinction, Larry and me and Keith, because it's bringing to attention something that people had really sort of neglected. But we need to remember, I think, and this is important, that when it came to decide constitutional questions, the earliest great constitutional cases, like Chisholm versus Georgia, or Calder versus Bull, or Fletcher versus Peck, or Marbury versus Madison, or McCulloch versus Maryland, in all of these cases, and many, many more, the courts appealed first to the unenumerated first principles that they believed underlie the Constitution, and only secondarily to the text, to affirm or confirm their conclusions reached on the basis of first principles. Nowhere, however, did they ever maintain that first principles could trump the meaning of the text. Never have they said that. But they did think these first principles came first in some methodological sense and could be applied by courts when assessing the constitutionality of acts of the legislature. Now, today, in our post-positivist world, we start with text.
Randy, would you want to?
2 paragraphs.
Okay.
Sorry. Today, we start with text and then recur to unenumerated first principles when the meaning of the text runs out, if not, unfortunately, sooner. But this does not change the basic fact that text is being supplemented by principles when the meaning runs out, and that is not interpretation, but what can be called constitutional construction. If my claim that construction is inevitable is correct, as an empirical matter, then originalists need to debate not only the appropriate approach to constitutional interpretation, but also the appropriate approach to construction. True, we will no more all agree about this than we do about methods of interpretation, but we only fool ourselves and confuse our audience if we try to make more of interpretation than a text will bear by collapsing the distinction between these two necessary legal activities. Thanks.
Okay, well, let me just go over, I'm not sure how long this will last, some of the points that Randy raises, and I'll see how far I get. Okay, so the first basic point, it sounds like much of the disagreement between us is focused in on vagueness rather than ambiguity. And I certainly agree with Randy that vagueness is a harder problem than ambiguity for the reasons that he says. On the other hand, I don't think that when a term might possibly be vague, that means that interpreters can come in with normative theories that are not part of the Constitution and resolve it. Instead, what one does is to look at the Constitution, figure out what the possibilities are, and then pick the one there's the most evidence for. So, I mean, to begin with, a lot of terms like the sort of light feather example, not the ambiguous part about it, but what would be light. A lot of, if you actually look at the debates, they take out vague provisions. They say, we don't want to put this in the Constitution. You know, that's going to be difficult to figure out the meaning for, right? So a lot of these things they take out. They're really trying to put things in that have sort of less vague understandings of stuff. But in the end, what's going to happen, when you got a provision, you have to look at the meaning of it. A lot of it has to turn on history, right? You look at how a term was understood previous to the Constitution, previous to it being put in, and a lot of times it's going to be, you know, the evidence is going to be close. There's going to be one will look at the common law rules at the time, and you know, you're going to have to guess. Well, you know, I think the line was drawn here. This would be a judicially manageable line. They were trying to do that as well. You're not going to be satisfied that, oh, you know, you're really confident that you're right. But that's going to be a lot better than simply saying, oh, my political theory says that this is the better answer, right? Sure, that sounds great if we all share the same political theory. But if the guy deciding the provision has a different political theory, one's not going to be so happy about that. Okay, so that's sort of one point. Randy says that certain principles that might resolve these matters are really not interpretation. So he uses the example of deference to the legislature. And if deference to the legislature was a background understanding rule, and we were to use that to resolve a tie, in Randy's view, that's not figuring out the original meaning. And I guess I just disagree with that, right? It seems to me that when we speak against the background of interpretive rules. When we speak, we use word meanings, right? Everyone is totally comfortable with the idea that there are certain word meanings and we're employing them when we speak. And we similarly do so with respect to interpretive rules. And we use different interpretive rules in different contexts. So if we're writing, you know, a medical report that follows certain normal regularities, and the first part of the report that usually does one sort of thing, and the second part, we would use those interpretive principles that come from that in understanding what it is. And the person writing it would assume that the readers would be using that. Well, if we're in a legal context and there's a legal background interpretive rule that says, look, in cases of ties, the tie goes to the legislature, then they are employing that interpretive rule in conveying their meaning. It's not something that's coming from outside the Constitution. It's not an external value choice. It's as much a part of the communication as the word meanings are. So I think Randy and I disagree on that point.